Hello, my name's Sarah Clarke and I've been asked to speak about the new European rules for dealing with market abuse, namely the Market Abuse Regulation and the Directive on Criminal Sanctions for Market Abuse. I'm going to address this topic by summarising the reasons why it has been decided that this legislation is necessary and also what the key changes are. The background. On the 20th of October 2011, the European Commission adopted a proposal for a regulation on insider dealing and market manipulation, known collectively as market abuse. An amended proposal was published on the 25th of July 2012, and in May of 2015, the regulation was published in the Official Journal, together with a directive on criminal sanctions for market abuse, known as the Market Abuse Directive. The regulation is of course directly effective on Member States, and it will enter into application in July of 2016. As regards the directive, Member States have 2 years to transpose it into their national law. The point of these two pieces of legislation is to update and strengthen the existing market abuse framework, which is currently provided for by the Market Abuse Directive 2003, known as MAD 1, which will be repealed. MAD 1 was adopted in 2003 and was intended to introduce a comprehensive framework to tackle insider dealing and market manipulation, jointly referred to as market abuse. The directive aimed to increase investor confidence and market integrity by prohibiting those who possess inside information from trading in related financial instruments, i.e. insider dealing, and also by prohibiting the manipulation of markets through practices such as the dissemination of false information or rumours and conducting trades which secure prices at abnormal levels, i.e. market manipulation, and also by strengthening the investigative and cooperation powers between member states in order to enable them to combat these sorts of activities. MAD 1 also created some important mechanisms for preventing and detecting market abuse, for example insiders lists, suspicious transaction reports, and the disclosure of managers' share transactions. It also imposed requirements on issuers of financial instruments traded on regulated markets to make public price-sensitive, i.e. inside information, as soon as possible, with limited possibilities to delay publication. In terms of enforcement, MAD 1 gave national competent authorities powers of investigation, for example access to data or on-site inspections, and the power to take administrative measures or impose what were termed effective, proportionate and dissuasive sanctions. Importantly, however, MAD 1 did not require Member States to make market abuse a criminal offence. Since MAD 1's adoption, the European Commission has identified a number of problems which can broadly be summarised under 5 headings. Firstly, gaps in the regulation of new markets, platforms and over-the-counter trading in financial instruments. Secondly, gaps in regulation of commodities, commodity derivatives and emissions allowances, which mean that regulators cannot effectively enforce MAD 1. Thirdly, lack of legal certainty, which undermines the effectiveness of MAD 1. And fourthly, insufficient powers to effectively investigate and combat market abuse among member states. Fifthly and finally, administrative burdens, especially for small and medium-sized companies. In addition to these, the importance of market integrity has also, of course, been highlighted by the current global economic and financial crisis and a number of notable cases. These are all reasons why the Commission has decided to replace MAD 1 with a regulation and also the directive. The aim is summarised in the preamble to the regulation. Paragraphs 1 and 2 read as follows. A genuine internal market for financial services is crucial for economic growth and job creation in the Union. An integrated, efficient and transparent financial market requires integrity, The smooth functioning of securities markets and public confidence in markets are prerequisites for economic growth and wealth. Market abuse harms the integrity of financial markets and public confidence in securities and derivatives. So what will the new legislation do? Well, the regulation and the directive will extend the scope of existing EU legislation to financial instruments which are traded on multilateral trading facilities, i.e. MTFs, organised trading facilities, OTFs, and also when traded over the counter, so that trading on all platforms and of all financial instruments which can impact on them will now be covered by market abuse legislation. The reason for this change is that MAD 1 is based on the concept of prohibiting insider dealing or market manipulation in financial instruments which are traded on a regulated market. However, since the adoption of the Markets in Financial Instruments Directive, i.e. MiFID I, financial instruments have been increasingly traded on MTFs or OTFs, such as swap execution facilities or broker crossing systems, or only traded over the counter. These new venues and facilities have provided more competition to existing regulated markets, and as a result they've gained an increasing share of overall liquidity and also attracted a wider range of investors. And yet these markets at the moment are currently not covered by the market abuse regime. Therefore, the market abuse regime, as it will be when the regulation and the directive fully come into force, extends the market abuse framework so that in addition to financial instruments described in MiFID II Annex 1 Section C that are admitted to trading on a regulated market, also defined in MiFID II Article 4, the new regulation also applies to any financial instrument admitted to trading on an MTF or OTF, as well as to any related financial instruments traded over the counter which can or are capable of having an effect on the underlying covered market. The point of this, according to the Commission, is to avoid regulatory arbitrage among trading venues, to ensure that the protection of investors and integrity of markets are preserved on a level playing field, and to ensure that market manipulation of financial instruments through derivatives traded over the counter is clearly also prohibited. The new legislation will also cover specifically attempts at market manipulation. MAD 1 currently does not cover attempts at market manipulation. However, the regulation will expressly prohibit it. The existing definition of insider dealing under MAD 1 already contained elements of attempted behaviour. However, in the regulation, these are removed and attempted insider dealing is prescribed as a separate offence. High-frequency trading also receives specific attention. The regulation provides an indicative list of high-frequency trading strategies which it prescribes as market manipulation. These include activities like quote stuffing, which is placing orders which have the effect of disrupting or delaying the functioning of a trading system. The regulation also extends the scope of the market abuse regime to cover market abuse occurring across both commodity and related derivative markets. Emission allowances are also reclassified as financial instruments under MiFID II. This means that they will also fall under the market abuse regime, as it is typically not the issuer of an emission allowance who possesses inside information. The standard definition of inside information doesn't sufficiently ensure relevant disclosure. Therefore, a specific definition of inside information for emission allowances is introduced by the regulation. The obligation to disclose inside information will be placed on companies with large installations that are regulated by the EU emissions trading system, as it is they who possess the relevant information. A late amendment to the regulation provides explicitly for the banning of the manipulation of benchmarks such as LIBOR or Euribor. Many financial instruments are priced by reference to benchmarks, and therefore any actual or attempted manipulation of these benchmarks can have, according to the Commission, a serious impact on market confidence and could result in significant losses to investors or to distortions of the real economy. Both the regulation and the new directive therefore prohibit manipulation of benchmarks specifically. Allowances are reclassified as financial instruments under MiFID II, and what that means is that they will also now fall under the market abuse regime. In addition, a specific definition of inside information that relates specifically to emission allowances is introduced. Benchmarks are catered for as a result of a late amendment to the regulation, which provides explicitly for the banning of the manipulation of benchmarks such as LIBOR and Euribor and others. Of course, it's well known now that many financial instruments are priced by reference to benchmarks, and therefore any actual or attempted manipulation of important benchmarks can have a serious impact on market confidence and could result in significant losses to investors or distortions to the real economy. This is why the regulation and the directive both specifically ban the abuse or manipulation of benchmarks. So how does the regulation reinforce the powers of competent authorities to detect market abuse? Well, it is intended to reinforce investigative and administrative sanctioning powers by offering necessary powers to competent authorities to perform investigations and improve deterrence of sanctioning regimes by introducing minimum principles both for administrative measures and for sanctions. The point of this is to ensure that regulators have access to the information they need in order to detect and successfully bring proceedings for market abuse. So, for example, it clarifies that regulators should have access to telephone and data traffic records from telecoms operators where there's a serious or reasonable suspicion of insider dealing or market manipulation. The regulation also grants competent authorities access to private documents or premises where there's a reasonable suspicion of insider dealing or market manipulation, subject to a judicial warrant. What this means in ordinary language is that authorities should have the ability to obtain and execute search warrants. So what about administrative sanctions that can be imposed for market abuse? Well, the view of the Commission is that sanctions that are currently available to regulators are often, in their view, weak and lacking in deterrent effect, and the purpose, therefore, of the regulation and directive is to introduce greater harmonisation of administrative sanctions. Common principles are proposed, for example, that fines should not be less than the profit made from market abuse, where this can be determined, and the maximum fine should not be less than 2 times any such profit. For natural persons, the maximum fine should not be less than €5 million, and for legal persons, not less than 10% of annual turnover, and Member States are free to exceed these limits. In parallel with this, the Directive for criminal sanctions for market abuse requires Member States to introduce criminal sanctions for insider dealing and market manipulation. Turning then to the Directive on criminal sanctions, the purpose of this is for it to complement the new regulation, the idea being that all Member States will have harmonised criminal offences for insider dealing, market manipulation and the manipulation of benchmarks, and also to impose minimum criminal penalties for the most serious types of market abuse offending. So why is this necessary? Well, the position is that MAD 1 currently requires Member States to adopt administrative sanctions which are effective, proportionate and dissuasive, but it left them free to decide whether or not to impose criminal sanctions. The Commission conducted research on the criminal sanctions and regimes imposed by different member states and took the view that current sanctions are lacking in impact and are insufficiently dissuasive, and that the result of that was that MAD 1 was being ineffectively enforced throughout the European Union. In addition, the definition of which forms of insider dealing or market manipulation constitute criminal offences diverged considerably from member state to member state. The Commission quotes by way of example that 5 member states don't provide for criminal sanctions for disclosure of inside information by primary insiders, and 8 member states currently don't do so for secondary insiders. Plainly, given that market abuse invariably is carried out across borders, this divergence in the way in which it can be treated in different member states undermines, in the Commission's view, the internal market and leaves scope for market abusers to conduct regulatory arbitrage, as it were, and choose jurisdictions which don't provide for meaningful criminal sanctions for particular types of offending. The Commission's view is that minimum rules on criminal offences and criminal sanctions for market abuse are essential for ensuring the effectiveness of the EU policy on market integrity. Common minimum rules on the definition of criminal offences for the most serious market abuse offences would also, in its view, facilitate the cooperation of law enforcement and judicial authorities in the Union, especially considering that the offences are, in many cases, as I've said, committed across borders. So which offences will be subject to criminal sanctions? Well, the Directive defines the 2 offences, insider dealing and market manipulation, and of course now the manipulation of benchmarks, which should be regarded by member states as criminal offences if they are serious and committed intentionally. In line with the scope of the regulation, transactions for certain purposes are excluded from scope, such as buybacks, stabilisation programmes, monetary policy and debt management activities, and also activities concerning emission allowances in pursuit of climate policy. The Directive also requires member states to criminalise inciting, aiding and abetting insider dealing, unlawful disclosure of inside information and market manipulation, as well as attempts at these forms of market abuse. It also requires that liability should also be extended to legal persons as well as individuals. Market abuse offences are deemed to be serious in cases such as those where the impact on the integrity of the market, the actual or potential profit derived or loss avoided, or the level of damage caused to the market is high, and there are other circumstances that might be taken into account in appropriate cases. The Directive requires Member States to ensure that criminal offences as defined in the Directive are punishable by criminal penalties and sanctions which are effective, proportionate and dissuasive when they are committed intentionally and at least in serious cases. In order for sanctions for the offences to be effective and dissuasive, the Directive requires maximum sanction levels of at least 4 years imprisonment for market manipulation, insider dealing and recommending or inducing somebody to engage in insider dealing, and 2 years for the unlawful disclosure of inside information. Legal persons will be punished by suitable fines and may include other sanctions such as exclusion from entitlement to public benefits or aid, temporary or permanent disqualification from carrying out commercial activities, placing under judicial supervision, judicial winding up or closure of business which have been used for committing the offence. Benchmarks, as I have said, are also included in the Directive, and the Directive requires Member States to provide sanctions in respect of natural or legal persons who transmit false or misleading information, provide false or misleading inputs, or any action which manipulates the calculation of a benchmark, including the manipulation of benchmark methodologies. A quick look at a couple of the definitions under the new regime. Firstly, inside information, which is defined in Article 7 of the regulation. This defines inside information in various ways depending on whether you are dealing with ordinary equities or the like, or commodity derivatives, or emission allowances, or those who are charged with the execution of orders concerning financial instruments. Interestingly, and of course appropriately, the regulation incorporates some of the European Court of Justice jurisprudence that there has been in this area in recent years. This includes the Marcus Geltel versus Daimler case, which was a referral from the German Federal Court of Justice. The Federal Court asked whether, in the case of a protracted process, which was intended over the course of a number of intermediate steps to bring about a particular circumstance or generate a particular event, account should be taken for the purposes of determining whether this amounted to inside information, only of whether the future circumstances or event was price sensitive or precise information, or whether the intermediate steps which go about to creating that event are also precise and therefore price sensitive inside information. What this means in practice is that when there is a negotiation, for example a takeover, and there are various bits of information in existence as a result of the negotiations that lead up to that takeover, then those steps, those intermediate steps that go to bring about the eventual event, are also to be considered as inside information, as well, of course, as the concluded transaction itself. That's how the European Court of Justice decided the case and said that where there's a protracted process intended to bring about a particular circumstance or event, then not only does that future circumstance or event be regarded as price-sensitive information or precise information, but also the intermediate steps in the process. This has now been specifically incorporated into the definition of inside information, which is to be found in Article 7 of the regulation. Article 7 gives effect to this by stating in terms that an intermediate step in a protracted process shall be deemed to be inside information if by itself it satisfies the criteria of inside information referred to in Article 7. Article 8 defines the various ways in which insider dealing can be committed. The regulation also doesn't reverse the decision in Spectre Photo Group case, another European Court of Justice case, in which the court held that if a person deals whilst in possession of inside information, then there will be a rebuttable presumption that the person used the inside information when dealing, and therefore falls within the market abuse regime. However, what the regulation does do is create an express defence to this presumption for firms that have put in place effective market abuse controls, including policies, procedures and information barriers, which haven't influenced or otherwise encouraged their employees to engage in insider dealing. So this brings me to the end of my rather whistle-stop tour of the new market abuse regime. If it works, it will result in a greater number of markets, financial instruments and types of conduct falling within the new regime. In practice, of course, whether we will see more market abuse cases being brought as a result of this regime will depend on the appetite of member states to effectively investigate and take action against this conduct. The practical reality is that this conduct is and will remain difficult to detect, and therefore it will be difficult to impose meaningful sanctions. Difficult, but not impossible, and time will tell as to whether this new regime will have a meaningful impact in terms of administrative and criminal sanctions.